The deputy claims that she is allowed to feel under the driver's bra as part of the pat-down, and the driver protests. During a Terry or traffic stop, law enforcement officers are generally allowed to perform a limited pat-down search of a person for weapons if they have reasonable suspicion that the person may be armed and dangerous. As the Supreme Court explained in the 1993 case of Minnesota versus Dickerson, quote, "The purpose of this limited search is not to discover evidence of crime, but to allow the officer to pursue his investigation without fear of violence. A protective search must be strictly limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others nearby. If the protective search goes beyond what is necessary to determine if the suspect is armed, it is no longer valid under Terry, and its fruits will be suppressed." Accordingly, even assuming that the officer had reasonable suspicion for the initial traffic stop, which she did not, and that she had a reasonable belief that the driver was armed, which is questionable, a court would likely conclude that the scope of the pat-down exceeded the permissible scope of a Terry stop and frisk. While an officer conducting a lawful pat-down may pat the exterior of clothing near the bra, a court would likely find that the deputy's decision to feel under the bra in this case was more invasive than permitted by Terry, as the level of intrusion appeared to be aimed more at discovering evidence of a crime rather than searching for weapons, especially since the deputy had no specific reason to believe that a weapon was concealed in that area.
No, you're not.
Okay. Where are you coming from today? Not your answer? Okay. Anything in the car that you're not supposed to have?
No.
Okay. Do you mind if I search the vehicle?
Yes, I do.
Okay.